Hi, I'm Jeremy Knindike, and you're listening to Forced from Home, a podcast about global displacement. In 1939, a boat called the MS St. Louis sailed for North America from Europe, carrying German Jewish refugees who were fleeing persecution in Nazi Germany. They were turned away by Cuba and sailed on to the United States, which also refused to accept them. Ultimately, the ship returned to Europe, and hundreds of those on board were later murdered in the Holocaust. In the aftermath of World War II, the world came together and agreed to a remarkable document that was intended in part to ensure things like that would not happen again: the 1951 Refugee Convention. It was negotiated as the world dealt with enormous displacement across Europe following the war. And the countries that negotiated it did not react to that displacement by building higher walls or hardening their borders. Rather, they agreed to this document that enshrined how they would work together to manage global displacement, and also guaranteeing some basic rights and protections for displaced people. That document turned 75 last week, and on its 75th birthday, the Refugee Convention is under attack around the world as never before. Here in the United States, we have arguably the most anti-refugee administration, certainly in the modern history of this country. But also in Europe and in other refugee-hosting countries, there is also a backlash against the convention and some of its protections, notably the protections against sending them back to harm in their home countries. So today we're going to dive into all things Refugee Convention. First, I sit down with Professor James Hathaway of the University of Michigan Law School. He is a renowned leader and expert on the convention, and we will talk about its history and some of the rights that it guarantees and how states deal with those. Then we'll hear from Eleanor Acer of Human Rights First, who is one of the civil society leaders shaping the response to threats against the convention. And she will talk about how the convention is being implemented today, some of the ways that governments are undermining and watering down their obligations, and why it remains such a vital tool for protecting refugee rights in the current political environment. And stick around afterward for 3 stories that we're tracking in this week's news. I am very pleased to welcome James Hathaway to today's show. James is an emeritus professor of law at the University of Michigan. He's written 2 of the leading books on international refugee law, one on international refugee definition and the second on refugee rights. Earlier this year, his contributions to the evolution of refugee law were recognized by the British government, who honored him with an honorary King's Counsel designation, and by the Government of Canada through his appointment as a member of the Order of Canada. James is one of the leading experts on refugee law and on the Refugee Convention, and so there's really no one better to speak with today about the 75th anniversary of the convention. So, James, welcome to Forced from Home.
Pleased to be with you.
So you are a longtime scholar of the Refugee Convention. Maybe let's start at a very kind of top line here. What are the basics of what the convention does? What problems was it trying to solve back when it was adopted in 1951?
So in a sense, you actually need to go back a little before that. It's the 75th anniversary of the UN's Refugee Convention, but refugee law itself goes back about 100 years to the League of Nations era. And the basics have pretty much stayed the same. Late 19th century, states, particularly the UK and the US, tried to erect pretty strong border controls. The reality of forced migration ran up against rules that said you may not come in, and desperate people did then what they've always done, which is find a way to get in when their lives are at risk. So refugee law was really, Jeremy, the metaphor I use, it's like a gate in the dam of immigration control. It was built by states who understood that if they wanted to have a migration control project, they needed to have a sluice gate, because sometimes the pressure on the dam would be so great that either water would flow over the top or the dam would break down. And refugee law is a way of, putting it really simply, maximizing the ability of states to do migration control in the face of involuntary, unstoppable human need.
I think that framing is important, that this was, in important ways, a tool for states. It was something states created as a tool for their own use, not something that it's often portrayed now. The Trump administration and some UK politicians have been portraying this as something that is tying the hands of states or restricting or constraining sovereignty. That's not what you're describing.
Of course, it does constrain sovereignty. That's what international law does, right? That's the whole point. The point is that we don't want the law of the jungle and we want to cooperate in ways that are mutually beneficial. But your basic point is absolutely correct. This is a treaty designed by governments for governments. There were some NGOs and academics observing, but this was done by states. And quite frankly, what people miss is that it's an incredibly balanced regime. Unlike any other human rights treaty, it builds state interests right into the human rights treaty and balances those with the rights of refugees. So governments knew from the beginning that they wanted a treaty that focused on self-reliance and empowerment. It's not about charity, and it protects state interests even as it does enable the most desperate as among the desperate ultimately to find a way to be safe.
Yeah. What are some of those ways that it establishes or defends the rights of refugees themselves?
Well, of course, the most critical thing is it actually is about, again, empowering refugees to look after themselves and the rights of their families. So this treaty has more economic rights in it than people, I think, appreciate. It's not so much about getting in or classic civil rights. It's about enabling refugees to educate their kids, to be mobile, to start businesses, to work, to look after themselves. And governments balance to that by only allowing refugees to gain rights over time. Refugees don't just grab a big bundle of rights the second they arrive at a border. They get an increasing number of rights as their connection increases. And the level of compliance is always measured by what a state is able to offer to someone else. It's never asking them to do what they aren't already doing for another group. So in all of those ways, there was an attempt to really make this a treaty that was functional for states, not so much a liberatory tool for refugees as it was a management tool for states.
And yet it's facing a lot of political pushback today, including from states like the US and the UK that were some of the original signatories and part of producing it, although the US didn't ratify it until I think 68. Some of the protections that are guaranteed by the convention, and in particular the protection against refoulement or forcing refugees back to harm or risk of harm in their home countries, are facing a lot of pushback and criticism from right-wing politicians and governments in some countries. Also, some of the provisions about encouraging what you're describing about access to education, access to the workforce, tools that would help countries integrate and naturalize refugees. What does this actually require of a country? How does this undermine sovereignty? Does this undermine sovereignty? Is there anything to those arguments?
It does limit their discretion. Again, if it didn't, it would be useless. Why bother having international law if every state is just going to do what it wants to do on its own? So, yeah, there are some rules of the road, if you will. It set out some lanes. You have to drive in the lanes. You have to follow the speed limit. But it doesn't tell you what kind of car to drive. It doesn't tell you what the destination is. It tells you a lot about how I think people can be treated in ways that enable them to get back on their own feet. You mentioned on refoulement, it always interests me that a lot of people pay so much attention to this duty. And I understand that in pragmatic terms, it's important, but actually it was a gap filler. It wasn't even in the original refugee treaties. We only added that because some governments were using informal processes to expel people. So it's an afterthought. The real point of the treaty was that people needed to have an ability to meet their own needs so that they did not become burdens on states, so that they did not become charity cases. And governments, I think, understood that if you actually enable refugees to meet their own needs and the needs of their families, that they actually are not a problem. They are not a burden. And so you're right. I think we've lost sight of some of that. The other thing we've really vilified, Jeremy, if I can just add, is what we don't talk about enough, which is Article 31, which is the duty not to penalize refugees for arriving without permission. This, I think, is the biggest one right now. The drafters knew in 1948-51 that no country issues you a visa to come make an asylum claim. Didn't then, don't now. And so they built in this rule that said, if you arrive without permission, but make a clean breast of your situation and come forward to authorities, that is not illegal entry. And I wish some people, not only in the Trump administration, but in other countries, would read Article 31 a bit more closely. If you want to start handing out visas to people make asylum claims, Switzerland did it for a period of time, but no government is doing that. So there is no alternative but to arrive and seek asylum without permission, because no permission will ever be granted. When you use the term vilification, I think you're right. That's what's happening, even though if for half a second we put ourselves in the shoes of a refugee and said, what would you do if your government was coming after you because of who you were? You would get the hell out and go to whatever state you could get to that would treat you decently, and you wouldn't stand in line for a visa if you thought you were in trouble. And that is the reality, and that's what the Refugee Convention allows people to do.
Yeah, and as you say, for all the discourse that we've had here in the US and in other countries about why don't refugees do things the right way, why don't they come in the right way, as you say, there isn't, in most places, a right way to do it. Governments don't create a right way to come in. And when you are fleeing material harm, you're fleeing for your life. That is the motivator. One, I think, related misunderstanding that we often see is what the convention actually requires a state do when someone makes that claim. So there's not a right to refuge per se. There is a right to seek asylum, but not an obligation by a state always to grant it. Talk us through how that works in practice and what the convention requires.
Yeah. One of the common misnomers is that states think they grant refugee status. They don't, and they can't. Refugee status is declaratory. You're a refugee as soon as you actually meet the criteria, long before you even arrive in an asylum state. And so a state can recognize what you already are, but it doesn't make you a refugee. It's a little bit, a friend of mine suggested a sports metaphor, which is somebody may declare who the most valuable player is at the end of the game, but they were already the most valuable player long before they were declared. Right? They played the game, they did whatever they had to do to qualify. And so the Refugee Convention doesn't require that states determine status because, quite frankly, the rights accrue as soon as you come under a state's jurisdiction. If you choose not to ask the questions through a process, then you're bound by the duties. If you want to interrogate the claim, that's your right. But you have to decide you want to do that. The refugee doesn't pay the price for you being lazy or not having the wherewithal to create a process. Their rights accrue automatically, and they accrue over time, starting with, notwithstanding what the U.S. Supreme Court said in Sale, which is probably the most reviled decision in refugee law history. No other country has adopted it, thank God. The U.S. Supreme Court mistakenly said that rights only accrue when you get to U.S. territory. That's wrong. They accrue when you come under a country's jurisdiction. And that happens when you grab somebody on the high seas or anywhere else. And the Refugee Convention was designed in a way that rights would accrue even if states choose not to act. So the onus then falls on the state that wants to look into your claim to set up a process to do that.
So walk through, if there were a sort of right way for this to go. Someone turns up at the U.S. border, gets into Mexico, turns up at the U.S. border with Mexico. What does the law actually require the U.S. to do when they present themselves? And now, leaving aside is what the U.S. actually does, but what is the U.S. supposed to be doing under the law?
So essentially, this is where the brilliance of the Refugee Convention comes in. Unlike every other human rights treaty, for example, the Women's Convention says women get all of these rights. The Children's Convention says children get all of these rights. The Refugee Convention doesn't work like that. It says there are basically what are 5 levels of attachment. You get a small bundle of rights when you come under a state's jurisdiction, a few more when you touch its territory, more still when you agree to enter its process following its rules, more rights still once you're assessed and found to qualify, and finally a small number of additional rights when you've lived there for a period of years. So the idea is to make this doable for states. So when you show up at the border, you are both under American jurisdiction and on its territory. And there are a couple of bundles of rights, limited though they are, that apply immediately and provisionally, including, for example, the right of children to be educated that applies instantly. So you cannot lock children up and refuse to let them go to school just because they've arrived to seek asylum. But more sophisticated rights like the ability to work, etc., can be delayed quite a long way into this process. So there's this balancing, Jeremy, going on between what people need to survive. For example, we give them a right to self-employment, to create a business before we let them compete with the domestic labor force. That was the compromise that enabled people to feed their families without being too much of an ask for an asylum state. So when they show up at the US border, they should provisionally get those immediate first two bundles of limited rights. And once they enter the asylum process and are found to be a refugee, their rights will just continue to grow.
Before they've gone through that asylum eligibility determination, how is a country supposed to determine whether they deserve those rights under the Refugee Convention or do not? Because this is where it strikes me, a lot of the controversy in the US over the last few years has basically been over who's a valid refugee, how much effort goes into determining that. And, I've talked to members of Congress who are generally sympathetic, who said, look, this is such an onerous process that it's creating a pull factor because people know by the time that they even work their way through that process, 6 or 7 years will have passed and they'll probably have a way to stay regardless. So that limbo moment, which can drag on sometimes for years, is really, I think, fundamental to some of the political backlash that we've seen in recent years.
I think you're right about that. And quite frankly, that's a monster of our own making. We don't need such a complex system. To start with, there are two things you can do for easy and difficult cases. For cases that clearly are people who don't have any claim to fear being persecuted for who they are, many countries have what's called a manifestly unfounded claims procedure that turns those claims around in a period of days. I worked with Canada a couple of decades ago to do the reverse, which is create a manifestly well-founded process. So you don't need a fancy hearing to figure out that an Afghan woman is a refugee. Let's not waste the money on it.
Yeah, exactly.
So if you were to deal with those two categories, you would actually end up with a comparatively small number of cases that really require resources. And we have a one-size-fits-all model that is incredibly inefficient, that could be fixed if we wanted to.
That is such an important point because as someone who's worked on refugee response overseas, when Somalis were flowing into Kenya during the famine in 2011, the Kenyans were not stopping them on the border to put them into a protracted administrative procedure to determine whether they had a good reason to be fleeing Somalia. When Ukrainians were heading into Poland a few years ago, European governments were not saying, hold up, we need to individually adjudicate each one of the 4 million of you. And if they tried to do that, most of those Ukrainians would probably still be living in tents in southern Poland waiting for a hearing.
Absolutely. Most refugees in the world never go through a formal refugee status determination process. And it, quite frankly, speaking perhaps against self-interest, but some of these systems create lots of work for bureaucrats and lawyers, and they don't actually deliver the resources to the refugees who need them. So even if you're just talking about the developed world, look at what Europe did for the Ukrainian refugees that you bring up. They put them into a process that was incredibly fast, incredibly informal, and provided 95% of the rights that the Refugee Convention requires virtually immediately. We can do it if we want to. The combination of manifestly well-founded and manifestly unfounded leads to a much smaller number of people who need adjudication at the level of detail that we give everybody.
I want to dwell on this for a minute because it really is fundamental to, I think, a lot of how wealthy, primarily Western countries have been dealing with controversy around asylum and refugee adjudication, and been some governments that characterize this as a pull factor, basically. Access to asylum, they characterize as a pull factor for people who they don't view as legitimate refugees, and they blame the convention for that. And so a few years ago, Suella Braverman, the former home minister in the UK, came here to Washington, just down the street from us at Refugees International, and spoke at the American Enterprise Institute, calling on the UK to withdraw from the Refugee Convention over this. US and EU practice in recent years has basically treated adjudication as a de facto pull factor, and they've tried to offshore that adjudication away from their own borders. What you're describing is governments have a lot of discretion here. It's not really the convention tying their hands. It's some of their own choices. But kind of talk through what you make of that pull versus push debate and implications for how to handle adjudication.
Let's be honest, if countries don't have immigration systems for ordinary non-tech pro people, then yeah, people are going to use whatever channels available to them if their life is miserable enough. Quite frankly, that's where America came from. It was people doing exactly that, right? My ancestors definitely did that. And I think we have to recognize that if you actually are worried about migrants using the refugee channel, maybe you should have a migration channel. And by the way, the US is learning the hard way right now what happens when you actually don't recognize the value that migrants contribute to your economy. But let's just put that aside. So states have tried deterrence. Hasn't worked. Hasn't worked for a number of reasons. As soon as one route dries up, another one springs up. And courts, thankfully, have intervened sometimes when the response has been unduly harsh and rights violative. But that's not to say that offshore adjudication is per se illegal. I actually do not think it is. But it has to lead somewhere. It has to lead to protection in a state party. And that's, I think, the challenge. And maybe we can get to this at some point. The challenge is we need a multilateral burden and responsibility sharing system that the Refugee Convention always intended should exist. If you read the preamble to the Refugee Convention, yes, the definition of the refugee and the rights of refugees are the core of the convention. But the preamble right up front says, this is going to create problems of unfair distribution as among states. And we've got to have a system to fairly share the burdens and responsibilities out. We've been waiting 75 years and we still do not have that system. So if you really want this to work in a way that's manageable and fair, then we have to get the UN Refugee Agency and others off of their backside to actually put forward a proposal for an international management system. And we have never seen that.
So one of the questions I wanted to ask you, and I think this is the perfect thing to get into, is what does need reform or modernizing? What aspects of the convention? And I think you've just hit on a really important one here, that it doesn't really provide guidance on how states should share the hosting burden. The Ukrainian example is really interesting in this respect, that for other populations in recent years, Europe has tied itself in knots over the frontline countries versus the interior countries, and where should people go and who hosts and who carries that. Whereas with the Ukrainians, with the political will, within the matter of a few weeks, began figuring out a system for distributing Ukrainian refugees across all the member states of the EU, and showed that the mechanics of that can be done when the political will is there. What would that look like at a global level?
That's a huge question. And I spent about 5 years trying to develop the response to that. But in a nutshell, I think what we need is a system of what environmental lawyers call common but differentiated responsibility. Different states doing different jobs under formula that actually reflect their capacity economically, territorially, and otherwise. The important part for people to understand going into this, and I know most of your listeners probably know this, but I really want to insist on this, is that it is not the case that countries like the US or Canada or Europe or Australia are being unfairly burdened by this particular system. 70% of the world's refugees are in lower middle income countries. 67% of them are in neighboring countries. They're not coming anywhere near us. And 1 out of 3 are in just 5 countries.
Yeah.
5.
And most people who are forcibly displaced don't even leave their country in the first place. They stay in their own country.
Absolutely correct. But if you want the real tragedy, and no one talks about this, except I will say the new High Commissioner, for the first time, his predecessor did not speak about it as often. The new High Commissioner, to his credit, said the protracted refugee situations have to end. 2 out of every 3 refugees in the world have been waiting an average of 20 years or more for a solution, and we're not doing anything about it. We've had no new accessions to the Refugee Convention. 1 out of every 4 countries is standing outside the system. The Global Compact was a bunch of hot air with absolutely no obligations. And it's about time that we take seriously some of what states are saying, which is the system does need to be better managed, but it does not need to be managed in a way that is brutal or punitive. We can do all of this if we just sat down and thought a little more carefully about what manageability looks like and what the basic needs of refugees look like. And the two are not in tension.
Right.
That's my basic message.
Yeah, and I think the shared but differentiated responsibilities framework, we've had for years a sort of informal understanding that the neighboring countries and the low and middle income countries adjacent to most of these crises will bear most of the hosting burden and the rich countries will pay for it. And we see that beginning to really implode now. Aid cuts are destroying that model. I think what the High Commissioner is trying to do, and for our listeners, if you haven't been following this, he has called for the world over the next 10 years to reduce by half the number of refugees who are stuck in the kind of protracted displacement limbo that James just described. A really tough aspirational goal, but absolutely the right goal. But even that is partly necessitated by the fact that this model of keeping refugees in camps is very expensive and can't be sustained when aid cuts occur, as has happened over the past year. To bring that also back to where you started some of the conversation, that's also not what the convention envisioned. The convention did not envision a system where refugees stay in camps for 30 years. It envisioned a system where they have access to right education and work, and they don't become that kind of a burden, and they contribute to the countries hosting them, which in the U.S. for many years was the case.
Absolutely right. And just to pick up on your point, Jeremy, I think if the High Commissioner's vision is to happen, it will not happen if we continue to run the system the way we do. We are spending dramatically more money to assess the refugee claims of the 30% in the rich countries than we have available for the 70% elsewhere.
Yeah.
Dramatically more.
Absolutely.
And quite frankly, I don't want to call it wasted money, but it's poorly deployed money. If we had common but differentiated responsibility, were countries like ours farther away from the sites of most refugee movements, were to see resettlement on a big scale as our contribution to the refugee regime, we could eliminate the protracted refugee situation in the time frame that the High Commissioner has in mind. If we do not start thinking of resettlement in a big way as a form of protection, his vision is not going to work. So I think the time is right now to begin reconceiving this idea that there's a one-size-fits-all model for doing right by refugees.
One of the aims of this podcast is to cut through mis and disinformation about displacement issues. And so maybe a question to end on is, when you look at the convention and how it's understood today and the role it plays and how governments engage with it, is there a particular topic or misunderstanding or maybe willful misunderstanding that you'd like to set right?
I think we've touched on it, but it's worth emphasizing that this is not a one-sided deal for refugees. This is a convention based on reciprocity of interests. It's designed by states for states to manage a problem faced by states. Yes, it does good for refugees, thank God, but it's not designed in a way that ignores state interests. And so I think, quite frankly, people blather on about the definition being outdated, completely nonsensical outside, at least of the American context. In other countries, we've reformed the definition to focus on serious risks to human rights that bespeak a failure of state protection. That's as useful today as it ever was. The rights that are in the Refugee Convention, the ability to educate your kids and to work and look after your needs, is that old-fashioned? I don't think so. So the only thing that's missing is the third leg of the stool that the drafters always assumed would occur, namely this system to operationalize international refugee law through burden and responsibility sharing. If we would just move on this right now, we could realize the High Commissioner's concerns about protracted refugees. We could realize developed governments' concerns about manageability. We could do right by the poorer states that do most of the work. And most importantly, we could actually get refugees back to a place where they can look after themselves and their families. And refugees should not be waiting 20 years for a solution.
Great place to end. James, a real pleasure to speak with you. Thank you so much. Really appreciate your time and wisdom.
My pleasure, Jeremy.
We just heard from James Hathaway about the origins of the convention and the legal framework that it creates to help states manage displacement and guarantee some basic rights for refugees. Now we turn to our colleague, Eleanor Acer of Human Rights First, who is leading civil society response defending the convention against attacks from some of the governments that are seeking to undermine it. So we're joined today by Eleanor Acer of Human Rights First, where she is the Senior Director of Global Humanitarian Protection. And she is a lifelong advocate for refugee protection. She's worked for over 3 decades on issues of the human rights of refugees and migrants, their legal representation, challenging their detention, and working on all aspects of U.S. asylum and refugee law and policy. She's one of the most preeminent advocates and scholars of the Refugee Convention, and she is currently spearheading a lot of the U.S. and global civil society response to some of the political threats to the convention. So she's a great person for us to talk to today about what the Refugee Convention means at 75 years and how it can continue to serve its really important functions many decades into the future. So Eleanor, we're really excited to have you with us on the show today.
I'm very honored to be here with you today, and much appreciation for all that you and your colleagues at Refugees International do as well.
Thanks so much for that. Let's start at a really high level. So kind of 30,000-foot view of the Refugee Convention at 75. It was written in a very different era, at a very different point in global politics. Why is it still relevant today? How do you feel the Refugee Convention is holding up in the modern world?
Yeah, so the Refugee Convention itself was drafted in the wake of World War II, though the concept of asylum has much deeper roots. Essentially, I think states realized that they needed to put the commitment to protect refugees into international law, into a treaty. So those commitments couldn't be just ignored or evaded when the political winds might shift, as they inevitably do. The reality is that the Refugee Convention and its protocol, are really more relevant today than ever. And we see that day in and day out. Some states continue to send refugees back to persecution, including the United States. There are failures to safeguard refugee rights in many countries, and those failures continue to push refugees, in some cases, to cross borders to find the protection of their rights that they need elsewhere in other countries. And by contrast, I think we know at this point that when states cooperate in the way that the convention contemplates, and when they work together to protect refugee rights, refugee situations are better managed, both for refugees and for states.
Yeah, I think that point is really important, that the convention was not just intended to be something that protected refugees, although it is obviously that. It's also a tool for how states work together. Say a little bit more about how that piece of it functions and why that's so important.
So the Refugee Convention calls on states to actually cooperate with each other, and that is absolutely essential because even at the time that the convention was drafted, there was a recognition that some states are going to be hosting very large numbers of refugees. And as we know, nearly 70% of refugees are hosted in low and middle income countries, often the countries neighboring major crises. So without support from other states, those states simply cannot manage to host refugees. They need assistance, whether it's through humanitarian aid, financial investments, or the kind of true responsibility sharing that comes through refugee resettlement. The United States has tried to portray the Refugee Convention as out of date. The reality is that many states have actually stressed its enduring relevance, and repeatedly over the last year have reaffirmed their commitments to it, including at a major meeting of UNHCR's Standing Committee, which was just held last month in Geneva. And the framework and the foundation of the convention is strong. The challenges really are challenges of implementation and adherence to the convention. And behind those challenges, there are challenges relating to politics, principled leadership, and really more broadly than that, a tremendous challenge to international law itself. So what we see playing out in the Refugee Convention context is not something that's just simply isolated to issues of refugees or migration. There are broader challenges here to the rule of law globally.
Right. You referenced some of the critiques from the Trump administration and their dissatisfaction with the convention. They've argued, for example, that it's strayed too far from the original vision of who should be considered a refugee, who should be able to access protection as a refugee. Deputy Secretary of State Chris Landau hosted an event on the margins of the UN High-Level Week last September where he basically said, we want to get back to preserving the convention as it was. There's far too many people who are taking advantage of it, who are not valid refugees. What do you make of some of those critiques from the current administration?
I think you have to look behind the rhetoric to see what the administration is actually doing. The administration has shut down refugee resettlement, issued termination notices for temporary protected status, and systematically attacked asylum. They're really shutting down access to a range of legal statuses that allow people from other countries to stay in the United States. And I think asylum is among those being particularly targeted because it provides actually a pathway to legal residence and citizenship. The administration's focus is, if you look at it carefully in terms of their rhetoric, even is overwhelmingly about where refugees should stay. Right? Administration officials have said that refugees should stay in countries close to home, essentially seeking asylum in those countries rather than the United States or Europe, and presenting refugees and migrants as threats to Western quote-unquote culture. And of course, those countries that are neighboring crises already host the vast majority of the world's refugees.
Yeah, and I think that can't be said often enough, that the countries that are bearing most of the responsibility for hosting the vast majority of the world's refugees are not wealthy Western countries. They are low and middle income countries neighboring where refugees are coming from. Totally agree that it is hard to take some of these critiques, any of these critiques from the Trump administration in good faith. But if you look at what they're actually doing, they're not trying to go back to some earlier version of the convention. They're not trying to focus on protecting a narrower set of people. They're really just excluding virtually everyone. There's a lot of, I think, frustration that the administration has felt about their hands being tied when it comes to refugee policy. And they direct a lot of that fire at the convention and arguing that, when Landau was talking about this last year, arguing that the convention needs to give more deference to states to set their own policies, and countries and governments should have flexibility and discretion over their own asylum policy. In reality, the convention allows for that, and it seems like many of their frustrations are more directed actually at U.S. law and the Refugee Act than at the convention itself. Help us disentangle a little bit. What does the convention actually require of a country? And then how much of current U.S. refugee law and policy is actually rooted in decisions the U.S. government has in fact made?
So the Refugee Convention and the protocol prohibits states from returning, or in French, refoulement, returning refugees to persecution, requires them to protect refugees' rights and to facilitate as much as possible integration and citizenship. And U.S. law has a lot more specificity about what is required. And in fact, the convention doesn't dictate the details of asylum policies whatsoever. It's actually laws enacted by the U.S. Congress that spell out the crucial details of U.S. asylum law. Most of the focus of the Trump administration is actually on how to evade that law, right? Evade the laws actually enacted by Congress. That's why we see a series of proclamations and directives and practices that don't adhere to the law, and in essence are efforts to do end runs around them, because their problem is, at the bottom line, the law itself.
Yeah, the convention is collateral damage from their real frustration with laws that Congress has enacted and that have had bipartisan support across administrations of all parties for decades and decades. But they don't want to go make the case to Congress to change the Refugee Act. And they, I think, know that would not pass. We're seeing, at the same time as the Trump administration is attacking the convention and refugee protection here in the U.S., European countries are also trying to water down their obligations and their practices. Other major refugee hosting countries like Pakistan are doing the same, pushing a lot of Afghans back into Afghanistan in what I think really has to be seen as refoulement. Do you see connection between those actions? Do you think that when the U.S. is backing away from the convention, it gives greater license or creates a permission structure for the countries that do host most of the world's refugees to do the same in some form? And are they feeling abandoned at the moment when the U.S. is undermining the convention and its own practice is also rug pulling a lot of the funding and diplomatic support it used to give to countries that host a lot of refugees? What does that global picture look like at this point?
Absolutely. The example that the United States is setting is encouraging other countries to send refugees back to persecution. It's essentially green lighting violations of international law, whether it's refugee law or customary international law that protects refugees from return to persecution. And Pakistan really is a prime example. The United States ended temporary protected status protections for Afghans, issued a termination notice explaining that somehow they would be safe returning to Afghanistan, even though many of them remain at grave risk of Taliban persecution if sent back. And the U.S. has traditionally played a strong role in supporting states like Pakistan, both in terms of providing aid to UNHCR and to agencies working with refugees, in terms of refugee resettlement, as well as in terms of diplomatic pressure, which really, that cannot be underestimated, the role that the United States has played, encouraging many countries on the front lines to continue to host large numbers of refugees. And we saw that play out. We saw the absence of the U.S. role play out in the refoulement of refugees from Pakistan back to Afghanistan. The U.S. cut its resettlement, the aid was cut, and as a result, Pakistan turned around and sent many people back to persecution.
Let's talk about the human dimension of what that actually means in practice. Like, what have you heard? You've talked to many refugees over the years. You're engaging with a lot of refugee leaders in the work you're doing right now to defend the convention against these attacks. What do they tell you? What do they say about what the convention and those protections have meant to them?
Now, refugees themselves know full well how important it is for states to be protecting them. At an event we had just earlier this week, a former client of Human Rights First spoke about the importance of the Refugee Convention and explained that but for its existence, she would have been sent back to certain death. It's not an academic issue, the Refugee Convention. It's a real-life issue that plays out day in and day out. In terms of refugees being sent back from Pakistan to Afghanistan, we know that there are people who faced grave risk of Taliban persecution. And that's everyone from people who have different religious views than the Taliban to journalists, human rights advocates, women and girls who will find their freedoms curtailed upon returning to Afghanistan.
There's a really powerful report in the Washington Post this week about some of those stories of refugees who have received protection, specifically in the United States over the years, what the convention has meant, what that protection has meant, the way that they've been able to flourish in their lives. Professional basketball players, business leaders, others who have opportunities to flourish as people, but also bring a lot of richness to American society because we welcome them here. And I think it shows what we're losing as a society here in the United States by not welcoming and not benefiting from the assets that they bring to American society. Do you feel like at a global level, as countries are seeing the U.S. doing this, are we in a kind of race to the bottom now in terms of adherence to the Refugee Convention? Are there any countries that are getting this right, that kind of are bucking the negative trend?
I do think that there are signs of hope. Many states, as I mentioned earlier, have actually reaffirmed their commitments to the Refugee Convention, and that's more than just rhetoric. It does signal a strong adherence to the rule of law and to refugee law. And I think it's part of why states go so out of their way to try to explain why they're actually adhering to the Refugee Convention when sometimes they're falling short. But I just want to say it's a mixed bag. In terms of states that are doing better, at least setting a strong example in some ways. So Spain, for example, launched a major regularization initiative just recently. I think there were 1.2 million migrants and refugees who signed up for a status of regularization. And that's a way to let people access their rights much more quickly, to spare the costs of individual adjudication systems that are very fact-intensive, as asylum adjudications can be. So it's incredibly efficient and will allow a lot of people to restart their lives and rebuild their lives in Spain and to work, most importantly, as well. Kenya last year launched its Sharika plan to improve refugee integration. Now, obviously, all efforts have their shortcomings as well as their successes, but that, I think, is an important initiative as well.
So we talked about the bad faith nature of some of the critiques that we're hearing from the Trump administration. What do you think are legitimate critiques of the convention? Are there areas that need reform? How could the convention or should the convention ideally be updated for the modern world? What would you want to change or adapt or reform if there were a political opportunity to do that?
Yeah, I think one of the gaps in the convention is the fact that it doesn't have real teeth in terms of enforcement, right? There's no court you can bring states to that violate the convention. There's no committee like the torture, to oversee it as you have with the Convention Against Torture, for example. And UNHCR, which does have a supervisory role, it inherently faces some conflict of interest as it's constantly, of course, dealing with its major donor states, who are sometimes the ones violating the convention itself. But you can't really, I think, take the politics out of it, or it's just an academic discussion. I will, though, say that the framework of the convention is very strong. And the reality is that improvements to implementation, which are overwhelmingly needed, do not require revisiting the convention. And even, if you could get states to agree to some kind of supplemental legal obligations, there's no reason they couldn't do that as well, as long as they were in addition to the Refugee Convention. That was, in fact, I think one of the ideas behind the Global Compact of Refugees was to encourage states to commit in a non-binding way, but to commit through pledges to do more, to supplement protection, for example, in resettling refugees or in supporting frontline states. I think there are definitely ways in which to push for additional commitments from states that don't involve actually blowing up the Refugee Convention.
For those who probably aren't as steep in all this as you and I are, so the Global Convention on Refugees was 2018, 2019, an agreement led by UNHCR, endorsed by many member states, to make some additional commitments to protect refugee rights, to create opportunities for people who've been displaced for a long time to have some sort of access to permanent regular status through local integration or resettlement, and to expand their rights to education and work opportunities and things like that, to not keep them on this kind of hamster wheel of aid dependency that so often is the result of protracted displacement. And as you say, none of that required and changes to the convention. All of that could occur within the framework of the convention, but exist alongside it.
And by its very nature, it was non-binding. It was a compact, not a convention. Right? And states didn't want it to be binding and repeatedly emphasized that they wanted non-binding commitments.
Yeah. And so when the U.S. withdrew from that a few years ago I think that was under the first Trump administration, they were withdrawing from something that didn't bind them in the first place. It was really just a kind of symbolic sort of insult to the concept of refugee protection, not something that meaningfully expanded or constricted anyone's flexibility. One of the larger aims of what we're trying to do with this podcast is to cut through some of the misinformation that's out there about refugee and displacement issues. So as you think about that landscape right now, what's one piece of misinformation or disinformation that you'd want to set right?
I think the impression left by some politicians and media that refugees are all trying to reach the United States. The vast majority are actually hosted in low and middle income states that are close to refugee producing crises. And related to that is this purposeful attempt to somehow portray refugees as shopping, right? If they try to seek asylum in the United States or Europe or Australia. And I've interviewed thousands and thousands of refugees over the years, and I'd say overwhelmingly, when refugees don't stay in neighboring countries, there are real reasons that they have sought protection in another country, whether it's the dangers they face of persecution, targeting, and violence in that country, lack of ability to survive or work or support their families, or who really critical needs to reunite with your family members. When you are displaced, the probably top priority is survival and finding your family.
Couldn't agree more, and it's a great place to wrap up. Eleanor, thanks so much for talking us through all this today.
Great. My pleasure as well. Thanks so much.
Turning now to the news roundup of 3 stories that we're tracking this week. First, late last week, somewhere between 50 and 60,000 people, mostly Moroccan men and boys, crossed into Ceuta, a Spanish enclave next to Morocco. This triggered a media firestorm and widespread hysteria among right-wing politicians in the US and Europe. But notably, according to the latest reporting, it does not appear to have been a particularly organic event. There is reporting that is coming out in the following days that this was prompted, at least in part, or facilitated, at least in part, by the Moroccan government. Some of the people who crossed over told reporters that they had been encouraged to try to enter by Moroccan border guards, that the Moroccan border guards who would normally have blocked them from trying to cross illegally into Ceuta did the opposite, stepped out of the way and encouraged them to go. It's not entirely clear why that was the case and what Morocco's motives were there. There's some speculation that we won't get into here. But it also validated the fever dreams of every anti-immigration right-wing hardliner, many of whom gleefully seized on this opportunity to call for all sorts of radical changes to European asylum laws and migration laws. Within 24 hours, virtually all of those people had returned to Morocco. It's not clear how many of them were even really seeking to migrate. And notably, while some right-wing European voices called for a fundamental overhaul of the Schengen Free Movement Agreement in Europe, that agreement does not even apply to this enclave on the continent of Africa. There are some lessons to be taken here, but what is really striking is there is a whole media ecosystem out there that is very eager to amp up fear of an invasion. There were multiple far-right British politicians, for example, who, when they saw this, said, all of these people may be coming to the UK. Some of them have left those tweets up even after these people have returned to Morocco. There is bad faith to go around here. There's bad faith by the Moroccan government, whose motives are not yet entirely clear. There's a lot of bad faith by right-wing politicians who are seeking to capitalize on this. And I think it has to be said, this is deadly bad faith and tragic bad faith. At least 72 people died, mostly through drownings, in the course of this surge across the borderline. More than 1,000 people required health treatment. And for what? It's not entirely clear. The only entity that comes out of this looking at all good is the Spanish government. The Spanish government has had, by European standards, a fairly liberal and progressive approach to migration and regularization of migrants. That came under widespread attack by right-wing voices in Europe after this incident. It's unclear if that is why the incident was triggered. But Spain, to their credit, are sticking by their policies. They did a professional and humane job of returning all these people to Morocco and have called out their European counterparts for the utter lack of solidarity and the immediate hysteria that accompanied this seemingly manufactured event. And frankly, Spain is right to do so. And an important postscript to this whole episode, there are people fleeing on this route who do genuinely need protection. They were not the ones who were getting the headlines, but after the 60,000 some Moroccans crossed back into Morocco, there were some people who stayed behind, mostly migrants from sub-Saharan Africa, some of them fleeing war zones like Sudan, who do need protection. And I think it underscores that there is a need for protection. There are migrants and refugees on these routes, but the scale there is nothing like what was reported on here. And it is a manageable challenge if the world chooses to manage it. And just always remember with events like this, the right-wing hysteria, the anti-migration hysteria, wants to present an unmanageable challenge, and they love nothing more than the sort of imagery that was coming out of Ceuta the other day. But the reality is a much more manageable challenge, in this case, a few hundred migrants who have stayed behind, who have protection claims that will need to be evaluated in good faith and handled accordingly. Next, we've talked repeatedly about the implications of a recent Supreme Court ruling here in the U.S. that has cleared the way for the Trump administration to terminate temporary protected status for a number of vulnerable populations who have had protection here in the U.S. Notably, TPS for Haitians has expired and not been renewed, and this exposes about 350,000 Haitians who live in the U.S. to the loss of their job and to possible deportation. As this turns into reality, employers across the country are being forced to lay off their Haitian staff, whose work authorization is now in question. About 70% of TPS holders across the board are engaged in the labor force here in the U.S., many in construction, healthcare, and caregiving. Haitians in particular have been instrumental in working as caregivers for elderly and people with special health needs, and the impact will be especially acute in nursing homes in places like Florida, where roughly 35,000 Haitians on TPS work in healthcare. This is obviously a major economic blow in the United States to lose several 100,000 people from the workforce, particularly in critically understaffed fields like home health care. It's also a huge social and societal problem. some of the reporting that has come out from people who are losing their caregivers, they bemoan, obviously, the lack of care, but they are also losing friends and supporters and some of the only people that they see every day. So there is both an economic and a social cost to the cruelty and the capriciousness of Trump's policies here. Notably, we're also seeing some real bipartisan support and pushback against this plan to deport Haitians and other TPS holders. Governor Mike DeWine of Ohio, a very conservative Republican, has been quite outspoken about how ending TPS for Haitians would be a mistake and would damage his state. And as we've talked about in past episodes, Congress can do something here. There is a bill that has passed the House with bipartisan support that would protect Haitian TPS holders. It is now in the Senate and should be brought to the floor and voted on. You can visit our Take Action page on the Refugees International website or look to the link in the show notes and write to your senator urging them to co-sponsor this legislation, bring the bill to a vote, and protect our Haitian neighbors. Finally, one other really important headline to watch, and that is renewed violence in Tigray state in northern Ethiopia. There was a war in Tigray from 2020 until 2022 between Tigrayan opposition forces and the Ethiopian federal government. That was ended by the Pretoria Peace Agreement in 2022, but that agreement was never fully implemented and remains very tenuous. And this violence is really worrying. It has already prompted people to flee from Tigray into Sudan, which of course is experiencing its own war and humanitarian crisis. And so you can imagine how worried and fearful people must be if they're fleeing Tigray to go to a place like that. There is a real risk that the Pretoria Agreement could fall apart. And if it does, the scale of conflict that might follow would likely eclipse the horrifying violence that we saw from 2020 to 2022. So this is one that we will continue to track closely, and it's one that we hope the U.S. and other governments that have some credibility with the different parties to this war can avert before it turns into something far worse. Thanks so much for joining us today. Don't forget to subscribe to Forced From Home on Apple Podcasts, Spotify, or wherever you get your podcasts. If you enjoyed the episode, consider donating to support our work at refugiesinternational.org or the link in our show notes. For more, follow Refugees International on Instagram, Twitter, and LinkedIn, and stay tuned for more Forced From Home episodes coming soon.